The authority is there because the legislature recognized that there is an overarching constitutional obligation to keep a balanced budget. In this case, the governor has to balance the fact that we have appropriations far in excess of the state's ability to spend.
And would you agree then that it is the legislature that determines what policies, what social policies are worthy of pursuit? And it is the legislature's obligation under the Constitution to set the priorities. And once those priorities are set by an appropriation becoming law, it is then the governor's obligation to carry out those pursuits and priorities as established by the legislature.
In this specific manner, the governor is having to balance priorities. As the New England case, I think, probably best describes, every bill that is passed...
Wait now. You say it is the governor gets to balance priorities, so then you're saying that the governor can change priorities?
I'm saying that in this unique instance, the governor also has the obligation to see that the Constitution is complied with respect to the balanced budget requirement.
I'm not, that's in the Constitution. The budget has to be balanced. My question is more specific than that. When the governor, if he has this authority, does he have an obligation to balance the budget, to prevent the deficit, to do so within the context of the policies established by the legislature?
I'm not sure I'm fully tracking the question, Your Honor.
The question really is, does the governor, when the governor sees that the law gets executed, have an absolute obligation to follow those priorities when he is determining to balance the budget so there's no deficit?
Well, he also has he can't spend money we don't have.
That's not my question. We have already got that premise established. He's balancing the budget. It's just how he does it.
Right.
And does he follow the legislative priority?
Your Honor, that is true, and that's what the commissioner and the governor has done here, is that they have unallotted for all the purposes that I referenced before, to make sure that we comply with the constitutional mandate of a balanced budget, to make sure that we don't have a financial crisis in the state of Minnesota, and that we balance the budget. In this case, there was an unallotment that equaled approximately, for the biennium, about 10% of the total MSA grants.
Okay.
And the MSA SD program, which is the subject of this, was eliminated as of November 1. But that represented a small portion of the MSA grants. There was not an appropriation for MSA SD. There was an appropriation for the MSA grants generally.
Well, and I think it seems to me that that really kind of highlights the issue. The governor is going in and making subjective decisions on what programs are more important than other programs. And while I understand, you know, the prohibition on spending to deficit, what authority is there for the executive branch to second-guess the substance of the legislation, to make choices internally? I mean, I could see the governor saying we're going to be 10% short of money this year. I'm cutting everybody 10%. That doesn't seem to me to conflict with legislative policy judgments. But as I understand it, the executive actually went in and said, I'm picking this, I'm not picking this. We're here to decide whether the unallotment was appropriately undertaken. Yeah. And that is a question that we have to decide. It is not a political question. It is whether either the statute or the Constitution allows the governor to do what he did here. And so, you know, that really is the question that we have to answer.